Hello, and welcome to the New York City Bar Association. My name is Yasemin Wieland, and I am a member of the Government Ethics Committee. On behalf of Jeremy Feigelson, our committee chair, and John J. Clark Jr., chair of the Banking Law Committee, I would like to thank you all for joining us tonight for tonight's program, The Financial Crisis and the Revolving Door. The revolving door has been a topic of near constant press scrutiny, it seems, particularly in recent months. To give just one example, in August, the New York Times reported on a study by a group of accounting experts that arrived at the conclusion that the revolving door actually strengthens enforcement results at the S.E.C. Yesterday, they reported on a study by a nonprofit watchdog group that arrives at the exact opposite conclusion. Tonight, we have the honor of listening to a panel of experts who will go behind the headlines and sound bites and discuss what impact the revolving door may have had, if at all, on government's response to the financial crisis, what the ethical rules of the road are governing individuals who pass in and out of the revolving door, and whether or not those rules should be reformed. Before we get started, I would like to introduce our moderator for the evening, CNBC senior correspondent Scott Cohn. Mr. Cohn is a founding member of the CNBC team and leads the network's investigative unit, Investigations, Inc. He also leads CNBC's coverage of white-collar crime and legal affairs. In addition to his appearances on CNBC, Mr. Cohn appears regularly on NBC News, NBC Nightly News with Brian Williams, MSNBC, Rock Center, and Today. Mr. Cohn is a 3-time Emmy nominee and a 2-time Cable Ace nominee. His coverage of the Bernie Madoff scandal earned a 2010 Loeb Award for breaking news coverage, and he also covered the Enron and WorldCom scandals. If you tuned into CNBC yesterday, you may have heard him speaking about the revolving door, too. And now I will turn it over to Mr. Cohn to introduce our panelists and tonight's format. Thank you for coming.
Thank you very much. It's a real pleasure and an honor to be here. And we have a great panel, which we'll get to in a moment. First, a little bit more about the revolving door. Franklin Delano Roosevelt, of course, established the S.E.C. in 1934, and to the surprise of many, appointed Joseph Kennedy, a reputed bootlegger and stock speculator, to be its first chairman. On that day, the revolving door began to spin. Asked why he would appoint someone many considered to be a crook to head the S.E.C. as its first chairman, FDR is said to have replied, "It takes one to catch one." So began the debate about the revolving door, which we take up tonight, as some very big players, particularly at the S.E.C., passed through that revolving door at about the same time. Mary Jo White, a former prosecutor turned white-collar defense attorney, is in line to be the next chairwoman. Robert Khuzami, the head of enforcement, who joined the agency from Deutsche Bank on Wall Street, has officially left the bank as of last week to go to the private sector. So the question that is central to these studies that Yasmin was talking about, do SEC officials, do enforcement officials in general, go easy on Wall Street because they hope to work there someday? And what about the broader question as we approach the 5-year anniversary of the 2008 financial crisis? Has the revolving door impacted enforcement? Are people getting off easy as the public cries for accountability? This week, as you heard, the Project on Government Oversight issued a study that concludes the revolving door, quote, blurs the line between regulator and industry. POGO examined 10 years worth of disclosures, some filed within 2 days of leaving the agency, people who wanted to go work, represent their new employers before their old employers. And it says that staffers routinely did, in fact, help corporations to influence rulemaking. As you heard last year, an academic study from Rutgers and Emory and the University of Washington came to a completely different conclusion, looking at 300 SEC lawyers and their career path after they left, and that study found that the more aggressive they were while at the SEC, the better they did in the private sector. So if anyone's going easy, the study concludes they're just hurting their own cause. Responding to the POGO report, S.E.C. spokesman John Nestor told me yesterday it is full of anecdotes that don't reflect reality. And by the way, he said that turnover at the SEC is actually quite low. Only a couple hundred people left a 4,000-person agency last year. Half of them either retired or went to another government agency, thus discounting the revolving door hypothesis. The aforementioned Rob Khuzami, who was originally supposed to be here tonight but could not be, goes further. He calls the revolving door a myth. So which is it? Is it spinning out of control or is it non-existent? Let me introduce our panel that's going to take that up. Thomas Perrelli was the U.S. Associate Attorney General, the third-ranking official in the Justice Department before rejoining Jenner and Block, passing through the revolving door as a partner last year. Susan Antilla is an award-winning journalist who writes for Bloomberg View and also contributes to CNN.com and TheStreet.com. It says in her bio, so I'm not saying this to, be impolite, she's been at this more than 3 decades. She has some definite views on the revolving door. Martin Grant is Chief Compliance and Ethics Officer at the New York Federal Reserve, where he has also worked in enforcement and litigation. He is not, according to his bio, passed through the revolving door, and he notes here, and as I assume most of our panelists do, he does not represent those of the New York Fed. His views are his own. Does not represent the views of the Fed or the Federal Reserve System. Nonetheless, if you have anything to say about interest rates, we'll be interested to know. Matthew Biben is a managing director and senior legal advisor to JPMorgan Chase. He's also worked as general counsel for NextJump, which is a technology company, and deputy general counsel at Bank of New York Mellon. Before that, he spent 12 years in government as an assistant U.S. attorney in the Southern District of New York and as an assistant DA in the Manhattan District Attorney's Office. Joseph Brenner is chief counsel in the enforcement division of the S.E.C, where he has been for 2 years. Before that, he was in private practice in the revolving door at Wilmer Cutler, where he focused on securities enforcement. And Rachel Barkow is a professor of regulatory law and policy, director of the Center of Regulatory Law and Policy, and director of the Center on Administration of Criminal Law, at NYU. She studied and written extensively about the role of prosecutors in the criminal justice system and also testified before Congress about the Consumer Financial Protection Bureau as it was formed, about this whole issue of capture or the revolving door. So what we're going to do is go down the panel and have everyone just give a brief sort of opening statement as far as where they are, what they think, and then we'll begin some questions, the fun part. So Tom, we'll start with you.
Sure. Thanks, Scott. I do think they asked me to be here in Rob's place because I have gone back and forth between government so many times, and it even started before I was born. My father was a career Justice Department guy, and I started working as a computer programmer at the Justice Department when I was 18 years old. I have been in and out a few times. I got out of law school, I clerked, I spent 5 years at a firm, and when I was a senior associate, I tried to figure out what to do with myself, and I really decided at that point I wanted to try public service, and I looked all over for the kinds of jobs I would be interested in, and I settled on I wanted to be an attorney at NASA, or I wanted to do computer crimes work at the Justice Department. And in the end, the guy I was coaching Little League with asked me to come work for him for Janet Reno. And I ended up then going at the Justice Department as counsel to Janet Reno, working in the civil division for about 3 years. Left, went to private practice. So through that revolving door, spent about 8 years really developing a practice focused on copyright and the rights of media companies, and then returned to government as the Associate Attorney General, and as Scott mentioned, the third-ranking official that's overseeing all the civil litigation in the United States, so environment, tax, antitrust, civil rights, the civil division, bankruptcy, a few other things. And that will be the best job I will ever have in my life. Sad to be 46 and have it all be downhill. But I left in March of 2012, took 8.5 months off with my 4 boys under the age of 6, and am now back in private practice. And as it says on our website, my goal is to build a practice that is very much about public policy disputes, about disputes with the government, based on my experience. So I am one of those folks who is trying to take the experience I gained in government and develop a private practice out of that. I am subject to the Obama administration's ethics pledge, which means I can't talk to the Justice Department for 2 years from the date of my departure. I'm barred from being a lobbyist for 4 years, and there are a slew of other restrictions as well that this administration has put in place. That's sort of by way of background, so you see where I'm coming at this from. I'll start by saying that notwithstanding the negative connotations of the revolving door, I would tell any lawyer in the world to spend some of their career in the private sector and some of their career in government service. I think there are no better jobs than those in the government, and I think everything I learned as a private sector lawyer made me a better lawyer for the government, and everything I've learned as a government lawyer made me better as a private sector lawyer. I've also had the opportunity of working with the tremendous people at the career lawyers at the Department of Justice, and the vast majority of whom are not looking for their next job, but are really looking to serve the public. To me, the issue of the revolving door is about a much broader question, which is how do we get the best and most effective government that really does work for the people in the interest of the United States? And that's got to be a group of people who are talented, who are dedicated to public service, who have the resources that they need, and are able to do the incredibly challenging jobs that we ask them to do in an unconflicted and unbiased way. And at least for law enforcement agencies, what I've been a part of, and particularly those that are lawyer heavy, I think it's a combination of things. I think that includes pay. I think that includes investment in resources beyond just pay, strong ethical rules, including restrictions on the job and when you exit the job, as well as recruiting a balanced and diverse workforce. Now, I know there's going to be disagreement already from the panel about whether government lawyers are paid too much or too little. My view on this is 15 years ago, it might have been different, but in an era where first-year associates make what federal district court judges make, that tells me that something's out of whack. And I do believe that I believe in general, if you invest in something, you will get better results, and I think that is true about our public sector lawyers. But investment goes more broadly. I think when I started practice, everybody thought that the government was the biggest and baddest litigant in town, and although the government has a series of tools like grand jury subpoenas and other powerful things, the reality is, in case after case after case, in every major matter, the government is out-resourced in today's world, and that's something that I again believe if you want strong regulation and effective enforcement, you've got to invest in it. But we also need strong ethical rules. The concerns about agency capture, about the revolving door, those are real because I think government serves the people best when those in senior positions are fully committed to the public service that they're doing and not worried about the next job and not thinking about taking advantage of their current position. And that's why I fully support the administration's decision to put on more significant ethical rules on its political appointees than I think any administration in history. But lastly, I also think we need to recruit people in government who come from a multitude of different backgrounds. A lot of the discussion that the panelists had before was about cultural differences. I think you need people who have experience as law enforcers. You need people with defense backgrounds. You need people from large institutions and small institutions, consumer advocates, those with deep expertise in a particular area, and those who come at it from a totally fresh perspective. That diversity, I've seen it work in government and can have a tremendous effect on the energy and innovation in particular places in the government. So I think all of those things are elements to making the best possible workforce. You're trying to create a government where people are not worried about their next job, and that has to be that they're not focused on currying favor with regulated entities, either by being tougher or less tough, but they also can't be focused that they will not be able to progress in their chosen career because the restrictions on their post-government career are so limiting. So that's the challenge. I think we'll hear from different agencies, and you'll hear the balance is struck differently at different agencies, and for good reason. I'm a big believer as well in transparency. I think the POGO study, among the things that I think is most important about it, is it lets people have a debate and discussion. I'm one of the first to tell you that there's a lot that happens in government that nobody actually knows about, and I think that having that kind of information available for lots of different agencies, I think would be a benefit to the public discussion about how we balance these different issues. So with that, thank you.
I look forward to hearing all these things that nobody knows about. We'll talk. Susan?
I've got a long presentation for you.
When I talk to defense lawyers about this revolving door issue, I usually get sort of a spiel that goes like this. They say, Susan, look, we are ethical. If we're representing Morgan Stanley, then we do our absolute best to represent Morgan Stanley. And if we're working for the S.E.C, we do everything that we can do to, represent the taxpayer. And the other thing that I hear is we're easily able to go back and forth from one sort of job to the other. And I believe that the lawyers who say that to me really believe that, but I think that this POGO study that we're all talking about gives us some reason to sort of step back and question what real life is for these same lawyers who are trying to be ethical. POGO it's a nonprofit watchdog, which you probably all know, and they went through thousands of S.E.C. records that they got through Freedom of Information Act, and the reason they got these records is that if you've left the S.E.C. In the first 2 years that you're out, you have to file a disclosure form. And so you learn lots of nice little details about what's going on between regulators and the regulated. And POGO found that between 2001 and 2010, there were 2,000 filings made by 419 former S.E.C. officials. That's a lot of action between the regulated and the regulators. So I want to give you some examples of what they found. They found disclosures regarding UBS, which settled an auction rate securities case in 2008 with the S.E.C. And as a result of that case, UBS should have lost certain privileges that they had, something called the well-known seasoned investor exemption. Who makes up these expressions? But there was actually a lawyer from Debevoise who was an associate director of investment management at the S.E.C. who got a waiver. He wrote a letter to the S.E.C. and got a waiver for UBS to keep those privileges. And in the letter that he sent to the S.E.C., he referred to UBS's strong records of compliance with the securities laws. Then in 2011, the S.E.C. charged UBS again, this time with rigging bond prices, and rigging bond transactions. And this same Debevoise lawyer asked for another waiver and got it. And again, he referred to UBS's strong record of compliance with the securities laws. A year after that, in 2012, another UBS subsidiary was charged with making misleading statements to investors. And this time, Colleen Mahoney, who was a Skadden partner who used to work at the S.E.C., she asked for a waiver for UBS, and she got it. And when I see the sort of thing that POGO came up with, this sort of information, I say to myself, how can the S.E.C. review this sort of correspondence? It's clearly not true that UBS is completely in compliance with securities laws, and yet they allow these exemptions to go through. Some of this research, it's not that it shows corruption, it really just shows sort of the relationships between the defense bar and current S.E.C. management. POGO did another report in 2011, and they talked about a meeting between Mitzi Moore, she had resigned from a senior counsel job, and Christopher Cox, who was then the S.E.C. chairman. She was representing the Financial Services Roundtable. It was 3 months after she had left the S.E.C. And on her agenda, and that's what POGO was able to dig up, the agendas for these meetings, she said that she made note of a positive mood change at the S.E.C. And I have to say, I read that and I said, positive for whom? I really got the feeling this was not positive for the investors who the S.E.C. was supposed to be taking care of. I don't think this is some big corruption issue. I think that what you're seeing in this back and forth that POGO's explaining and some other things that I'll get to in 1 second, it's that you just wonder what side are the regulators on. A couple of my Bloomberg colleagues last year, they unearthed an email exchange in 2009 between David Becker, he was the general counsel of the S.E.C. at the time, and Annette Nazareth, who had moved from being a commissioner to working at Davis Polk. And Becker, in his email to her, referred to the inanity of the investor advocate. It was a new position that was opening at the S.E.C. And she wrote back to him and she said that the prospect of a consumer financial protection agency made her ill. And it's really hard to read these exchanges and not feel a little worried about whether there's anybody watching out for investors here. And in a lot of these back and forths that you hear about, the revolving door, we get bogged down in details about how long before you can work for a client and how long before you can do this and how long before you can do that. And there's not a lot of discussion about the real life people who are impacted by regulation or lack of regulation. This is not an issue of breaking the law, but I think that this is flashing warnings to us that we should be looking at this as everybody here is doing, and I think that's constructive.
Martin.
So, I guess the challenge of people in the challenge of those in public service is to do good and at the same time be good. And the ethics, the government's conflict of interest law and the ethics programs that have been established around the legal framework have aided efforts by, at least at the Federal Reserve, but I think all government offices, to introduce a set of rules that guide the introduction of people into their staffs who are from the private sector and their exit to the private sector. And so today I was going to talk about a little bit about the rules of the road, but before I venture there, I will talk a little bit about the Federal Reserve's experience with the introduction of people from the private sector, and especially during the financial crisis. And generally, for someone who has been at the Federal Reserve for about 23 years, we faced an enormous challenge in the last 5 years that we were aided in our challenge by the influx of talented people from the private sector to help us in very specialized areas of both law and policy and financial instruments, so that we could accomplish a very important mission. And so we are, so public service is, well, the public is served well by talented people wherever they come from in the government. So that's the number one thing. Now, there are appearance risks associated with the introduction of people from the private sector into official duty and also as they leave. And so there are a couple of rules that I was going to talk about today, and one is what we call the criminal conflict of interest statute. And the basic set of ideas that the criminal code has is that employees may be disqualified from working on some matters while seeking post-government employment, and then after government employees leave, they're prohibited from engaging in certain activities. In certain activities, generally contact with the government for some period of time, and the administration of these rules is an important aspect of how effectively I guess agencies and organizations deal with this risk, and especially at the Federal Reserve, we have been subject to so much criticism over a period of time that we have been very careful to have conversations with all of our candidates in recent years prior to their joining the Fed, and those conversations focus on their resume and their potential job duties in the future, their financial interests, and where they serve as examiners. There are restrictions for them from those individuals working in those institutions where they previously were employed for about a year. And so there's a whole set of regulation and guidance as people enter our organization. And as people leave, we have conversations when they begin their job search. And that is something that requires a lot of trust in an organization and a lot of communication. And so we are dedicated to having those conversations so that our staff avoids all the kinds of pitfalls of going too far down the employment track with firms while they may be working or associated with matters that would pose a conflict of interest. So, I guess I'm here to say today that there are ways to manage the entry and exit of individuals as they enter and leave public service, and that the extent that there's a revolving door, that there are ways to mitigate those risks.
Terrific. Matt.
Thanks, Scott. What I would first let me say, my views don't necessarily reflect the views of JPMorgan Chase, although they do reflect the views of right-thinking people everywhere. So I'm going to agree with a lot of what my co-panelists have said. My perspective is a little bit different. I do think As Susan said, this isn't a corruption issue. I do think there's an appearance issue, and I think part of addressing the appearance issue has to do with transparency and some set of guardrails or period of intercession between the government service and advocacy to that same agency again. But where I come from is out of the U.S. Attorney's Office, as Scott said in my introduction. And what I think was most useful in terms of my education about being in the U.S. Attorney's Office, with the Southern District of New York had a model. It was not a formal model, but it was the model over the last probably 3 or 4 decades, where the chief of the criminal division was always someone who had been in the office and then come back to the office. They had been out in private practice. They had represented defendants oftentimes before the U.S. Attorney's Office, and they came back, and that was a counterbalance for a bunch of young, incredibly smart, energetic, dedicated assistants who thought they were pursuing good and were in a culture where they were rewarded for being as aggressive as justice allowed, and yet, to their minds, what they were doing was completely appropriate, and yet the balance of having a seasoned attorney who had had the experience of being on the other side, I think really made for better decision-making around charging decisions and whatnot. So to my mind, the revolving door, I haven't come up with a better characterization, is actually a good thing. And indeed, I think part of what government suffers from is that there's not enough mobility in and out of government. So as I think about what are the worst areas of government, the parts of government that function poorly for their constituents, for all of us as citizens, I think of places like the Department of Motor Vehicles, where there is no mobility, there's no revolving door. Indeed, what you have is intransigence and bureaucracy and lack of innovation and all of the things that I think characterize a government waste. And so by contrast, I think of the S.E.C, because it's topical with POGO, or any other place where you do have mobility, you have senior people coming in who bring ideas and energy, prior experiences, and they can help drive an agenda of change and make sure that the agency is fulfilling its mandate and yet is responsive to the regulated entities that are appearing before it. And this isn't just true for the S.E.C. I think it's true for agencies more broadly of the government. I then think of enforcement, whether it's civil enforcement or criminal enforcement, and I also think it seems a little myopic to focus exclusively on S.E.C. capture, given the competitive regulatory environment we're in. I was Deputy General Counsel of Bank of New York, as Scott said. I'm General Counsel of Consumer Businesses at JPMorgan Chase today. I've negotiated across the table from former colleagues, from former classmates at both of those institutions, multiple non-prosecution agreements, consent orders with regulators. So I've had the privilege of being on the other side, and not one of them has given me the benefit of the doubt once. So the idea that in some way that there's these kind of barroom conversations that take place where men and women recess and say, oh, it's a good thing that somebody was on the other side of the table, because if not, we really would have been railroaded. To me, it is inconsistent with my professional life. And again, I think it's inconsistent with common sense, because there is such a competition right now. Attorneys general aspiring to be general across the country are now jumping into securities regulation and regulation more broadly. You have agencies like the Department of Financial Services in New York with a very aggressive superintendent who's jumping in. I just think that the reality of the world today is that if there is complacency in one organization, it's going to be picked up by another organization, and you're not going to have people getting a pass. On WICSI exemptions for the POGO on WICSI, I take the point around the appearance, but truthfully, I think if you studied WICSI exemptions in general and the characterization, whether it's by an attorney who worked for the S.E.C. and an attorney who came out of another position, they're all going to say the same things. They became pro forma around those submissions, truthfully. And so I think what POGO did is fascinating. I think it's good to shine some light on these topics. As I said, I think what's important is transparency. It gives transparency. And I do think whether the Obama administration is right with 2 years or the prior administration's 1 year, I think there should be some period where, for appearance's sake and otherwise, you cool off as you come out of government. But fundamentally, I think it's important that there is mobility in and out of government. I think it leads to better government and better results. And I think there's not enough of it in some areas of government, including municipal government.
Joe.
Thanks, Scott. I also have to start with a disclaimer, which is that any views I express are not necessarily those of the commission or any of the individual commissioners or any of the other staff members or any former staff members who may have gone through the revolving door. I want to make 2 points, and the first one is really to start with kind of the elephant in the room that Scott teed up, which is the government's response to the financial crisis, because that's sort of the premise for this. And I want to take that on directly by saying that I think from the SEC's perspective, I mean, our financial crisis enforcement cases have been a terrific success. And I say that really for two reasons. One is we've put an enormous priority on them and an enormous amount of time and effort into them. And one of the things that we did, which is relevant to our discussion tonight, is we went out into the real world and hired experts from the industry to help us in investigating those cases, analyzing those cases, and trying to figure out and understand what happened. We hired people who were experts in securitization of structured products like CDOs, RMBS securities. We hired people who were experts in trading of those kinds of structured products. And that was in response, frankly, to criticism we had received that we were behind the times in expertise compared to the industry. And that was a tremendous benefit to us. And one of the things we'll probably talk about as we go on tonight is there's really only one place to find industry expertise, and that's in the industry. And it's just a reality of the world. The second thing I would say about our financial crisis enforcement cases is that they have really been tremendously successful. I mean, we have brought cases against more than 150 entities and individuals in that space. Those cases, with respect to the individuals, we brought cases against more than 65 people who were CEOs, CFOs, senior officers of companies, and together those cases have brought, monetary results of close to $2.7 billion so far. And the substance of those cases have been very strong, aided in large part by the folks we brought in from the industry to help us understand the practices like the sales of those products, be able to sort through whether people were being given the material facts they needed to be given when they bought the products, or whether the shareholders of the companies who we were talking about got fair disclosure of the risks to their balance sheets from the mortgage-related products that they have. And so, from my perspective, starting with the response, I think our response has been very successful, and when you look at bringing cases against 150 people and entities in this space, compared along with all the other things people are expecting us to do, from insider trading to market manipulation to Ponzi schemes to offering frauds, it's a very successful record from my perspective. And so that leads to the second point, which is how were we able to do that? And I think circling back to some of the things other folks have said, I think a large portion of the credit of that goes to the fact that we have a mix of talent and experience and sort of a reservoir of the things you need to bring these cases that really allowed us to do it. We have a mix of people who are longtime government employees, who have investigators who've been doing this for a long time. They have the experience to know which rocks to look under, how to do these cases. We have people like on the other end of the spectrum like me, who have been in private practice for 25 years and only recently come into the government. We have people like Rob Kazami, who you mentioned, who really spent most of their careers in public service at the S.E.C. and in the Justice Department, a much smaller period of time in private industry. And we have people like the experts who I was talking about, who we brought in. And I think it's that mix of talent that brings in the different kinds of perspectives that allows you to get good results. And you wouldn't get the same results if it was all at one end of the spectrum or all at the other end of the spectrum. It's really the DMV example. You don't want all the people who've been sitting behind the counter for a long time. You want a mix, and it gets you where you need to go.
If there was a revolving door at the DMV, I don't know where people would go, but that's for another time. Rachel.
All right, so what I want to talk about is less about the revolving door and what it is that we're worried about when we say it. And I think what that is this idea that industry has an undue influence over regulators. And in this case, it would be, because the person who represents the industry knows the regulators and has kind of an inside track. But I actually think it's part of a bigger concern that the public has, which is the idea that the regulators are really on the same team or focused in the same way as the entities they're supposed to be regulating. And I think that that's a valid concern, and it goes to what some of the panelists have already talked about, which is the idea that you might get people who work at an agency all sharing the same kind of mindset. And so I think if you ask people, who's captured? Some people in the public or among critics of this phenomenon would say, Tim Geithner. But he's never worked in private industry. He's always been a public servant. But I think he'd be an example of the people who talk about capture, where they'd say, we're concerned about that. We're concerned that he was captured. But it wouldn't be because of his prior employment in the private sector. It would be because of his associations with bankers that he met as a regulator in other capacities, or that he knows from other contexts. And so what I think the real issue is that at agencies you can often get people who just share a similar worldview. And it's the worldview that's the perspective of that industry. So I imagine that not too many people go to work at the Fed who aren't interested in banking, and probably not that many people who are interested in banking are interested in it because of consumer issues. It's probably more the allure of interesting financial instruments. And so what you might end up having is that everybody shares the same kind of basic perspective. And I think it's all in good faith, and I don't think there's necessarily anything, there's nothing untoward about that. And I think that you're exactly right, that you want people who understand an industry to be regulating it, because in order to regulate effectively, you have to have people like that. But there is this problem. There is this question of whether or not the regulators have enough diversity of perspective, as we already heard. And I think that's a real issue, and I don't think a cooling off period remotely gets to that, because it's not really the problem. The problem isn't you're going to go work someplace else after you leave. It's who's going in there in the first place, and do they all share a similar perspective. So if that's the real problem, that you might have people who are don't have enough diversity of viewpoints, then I think the solutions are going to be different. I think you're going to want to do different things. So I think you do want to try to get people to serve who come from different backgrounds than the ones that are traditionally going in that direction. So you could think about how you actively recruit consumer advocates. Maybe you create a position at these agencies of consumer advocate, someone who's there at the agency to sound the alarm when it looks like the agency isn't doing enough, a kind of internal watchdog that could be the source of that transparency. And then the agency would know there's this other voice. I think it's also a really good thing that we have attorneys general and we have other enforcement mechanisms, because I think that's another way that we could figure out. Because how do we know if the S.E.C. is bringing enough cases? There's no benchmark. We can't know the cases that aren't brought. But one measure of figuring it out would be to say, hey, well, why is the AG bringing this case and you're not? And I think we've seen that. We've seen examples where attorneys general have brought enforcement actions in the past when it looked like the S.E.C. didn't want to. And then we can evaluate whether or not the AGs were correct to do so. But I think that's a healthy and good thing, and therefore we would not want preemption, for example, of attorneys general from doing that if we thought that that's a good way to make sure that other voices are heard. The other thing we could do is we could have other agencies have a kind of oversight or consultative role to try to figure out whether or not financial regulators are doing enough. So if we thought an agency like the FTC or the Consumer Financial Protection Bureau were well equipped to do that, they could be some body that these agencies had to consult. But all of these would be solutions that are far different than the post-employment restrictions, because I actually just think it's almost not worth it, because I think the public doesn't really care if somebody waits a year before they go into the private sector. It's still going to be reported when they do that they used to work at the government 2 years ago, 1 year ago, 4 years ago. It's going to follow them forever. And I think what they really want, I think what people really want is an idea that the government is as focused about people on Main Street as it is about Wall Street corporate executives. And I think you're going to have this appearance problem unless the government does a little bit more to try to establish, and genuinely does, get more voices on its regulatory bodies that have more diversity of background than just working in the financial sphere.
We're going to save some time to get your questions. I believe there are some cards if you want to be thinking of questions and writing them down, or there'll also be a microphone. So think about that as we go on, but first it's my turn. And Joe, I want to start with you. Since we spent a bunch of time beating up on the S.E.C. all the way back to Joseph Kennedy, I want to get your response a little more directly to the POGO study. And I realize you're speaking for yourself and not the commission. But when you hear about employees within 2 days of leaving filing to represent their new employer before the S.E.C. The POGO study talked quite a bit about the regulation or lack of regulation of money market mutual funds that was very much influenced by former S.E.C. people who were now working in private industry. And the fact that every time, I think I've covered every FCC chairman back to David Reuter, and now we have a former prosecutor coming in for the first time. We had a regulator in Mary Shapiro, first time there was a career regulator coming in. But before that, Wall Street has always wanted somebody that understands them. The public doesn't seem to like that. So let me get your response to the POGO study in that frame.
Sure, I'll be happy to start that off. It's obviously a complex subject. I mean, the POGO study is interesting from my perspective, mostly for the facts that it reports as opposed to the speculation of what might have, maybe, possibly could have influenced somebody to do something. And I guess the facts that I found most interesting in it are, number one, the real effectiveness of the agency's ethics process. I mean, we talked about a little bit earlier that, most of the detail in the POGO study was made possible by the fact that the S.E.C., unlike most other government agencies, requires its former employees to file reports for 2 years about every time they want to come in, and they have to get permission from the ethics office to be able to do that. And I think you look at the fact of that, it's working, and that's how you can get the sort of sunlight into this process and have the debate that we're having here. The second thing that I found interesting, and this goes to the question you raised, whether it's on the regulatory side or on the enforcement side, the POGO study focused on the regulatory side, for example, a number of instances where former employees appeared on one side of that issue. And it concluded, can't really tell whether they had any influence or not. What it didn't focus on is, did former employees appear on the other side of that issue? I'm almost certain they must have. And so that you look at that and you sort of shrug your shoulders and say, what does that mean? There were employees here, there was former employees here, there were former employees on the other side. We came to a result. What does that tell you? I don't know that it tells you anything too compelling. And on the enforcement side, and this goes back to some of the things that Susan mentioned earlier about the waiver requests and the exemptive requests and the no action letters, the real telling point that I saw on the facts was there was no effect on the outcome. I mean, the favorable results that the study reported were obtained by people who were former employees, people who weren't former employees. And if you sort of add up the numbers in the report, more people who weren't former employees got the favorable results than the ones who were. So I think when you look at the facts, it's interesting information. It's hard to really draw any conclusion that should make you uncomfortable.
Susan, I want to let you respond to that, but also you heard Joe, you heard Martin talk about during the financial crisis, these agencies needed industry people in order to understand what was going on, in order to deal with it effectively. How can we do this if we don't have a revolving door?
Well, I don't have a problem with there being people who are experts helping securities regulators. So that's on the one hand. On the other hand, part of the reason that we're here talking about this is that there's this feeling among the public anyway that we haven't done much about the people who caused the financial crisis. Now, I've looked at the S.E.C's page. They have, a big web page full of their accomplishments in going after people from the crisis. But if you really look closely at it, it's not that there are no companies that you've heard of, because there are. But one of the things that we all object to is that weren't there any people in back of this? Weren't there any, people at banks you've heard of who were responsible for some of these things? And, I asked the S.E.C. to send me a list. They claimed that there were 65 high-level people at companies who they had brought actions against. And so I looked at that list, and indeed, I had heard of some of those people. But some of these people, if I said Brook Street Securities to you, I don't know, maybe some of you who've watched like penny stocks and sort of schlocky brokerage firms know of Brook Street. I know of Brook Street because I write about those kinds of people. But Brook Street has had state securities regulators coming after them since the mid-1990s. So why is it an accomplishment that, now in 2013, the S.E.C. can say that they went after officers at Brook Street. I mean, these are like little tiny people who Brook Street didn't bring down, as much as I don't like what they did to a lot of small investors, they did not bring down the financial system. And so we keep coming back to this question of why not the big players? And I mean, I have some thoughts on that. I think over the years it's like we just keep cutting back on accountability. You know, we have deferred prosecution agreements on the criminal side. The S.E.C. settles and you don't have to admit what you've done or if you've done something. That makes it harder for people to sue you in a private lawsuit. Even if you do settle with the S.E.C., you can get back all of the exemptions you would have lost. And I'll say one other thing that always bothers me, which is the whole industry has been less culpable for 25 years. I really think that in 1987, when the Supreme Court ruled for Shearson in the McMahon case, which allowed brokerage firms to force their customers into arbitration, I think that was a huge move away from culpability. And you know, going into private arbitration, not being able to sue a broker who's done something wrong, I think that's part of this mindset that we see now, where you know, there's no accountability.
Tom and Matt, I want you to pick up on that, but also bringing it back to this revolving door idea. And there is this sense, I mean, there's this sense that the people responsible have not been called to account. You compare this to the accounting scandals 10 years ago, and everybody wanted Ken Lay in handcuffs. They got it. There's a lot of people that feel that that was a miscarriage of justice and prosecutors not being restrained. Are we seeing now prosecutorial restraint or a revolving door effect?
Well, happy to go.
Go ahead.
Let me briefly comment and then let Tom say something more intelligent. I don't actually think it's either of those. And I think what's so striking, and I understand, I really do at some level, the desire to hold individuals accountable for the financial crisis. But you've had a liberal Democratic president who's now been reelected. You have multiple prosecutors who would want nothing more to serve the constituent, the public who is crying out for these prosecutions to make those cases. This isn't a revolving door. These are people who are oriented toward making those cases, enforcement cases, criminal cases, and yet the cases haven't been made. And so I think at some point you have to say there was not individual conduct sufficient to establish criminal liability or enforcement liability if all of these audiences keep looking at it, having nothing to do with where they came from, and keep coming to the same conclusion. There's not a case here to be brought against, you know, fill in the blank from 2008.
And I'll take it as sort of a little bit different direction, but sort of focused on the conversation about are you seeing a decline of accountability? And just going from my own personal experience and painful experience for Matthew. But you know, one of the things that I spent an enormous amount of time was the mortgage servicing settlement, which was $25 billion. And there's robust debate about how much is enough, was this enough? But there was a fundamental question that the government, I think, and you know, all the AGs and many agencies had to face in that context, which is there is no question that there were a lot of people who wanted us, whether civilly or criminally, to pursue those matters to the absolute end, litigate them, because if you won in litigation, you would, you know, get potentially the greatest possible recovery. But that would take a long time, and this basic question of, is it better to try and reach a resolution which is going to bring the most money into the Treasury, bring the most benefit to the consumer sooner rather than later? I hear all the arguments about not putting people in jumpsuits, but I think it's hard to debate that the current enforcement efforts have gone far beyond enforcement efforts really ever historically. If you look at, you know, we're now in a world where the $1 billion fine is, you know, you just kind of roll your eyes at. It wasn't very long ago that was a shocker, you know, and so I think we are, you know, prosecutors are using different tools, and there is a very good public policy debate to be had about the non-pros, the deferred pros, whether to prosecute, what the costs and benefits of each of those, whether going civilly, whether going criminally. Those are important debates to have. prosecutors have made whatever the choices that they've made, and I think we can debate those, but I don't think it's for lack of trying or lack of an interest in actually advancing the public's, what is ultimately in the public interest. Folks may just take a different view about what that is.
What about the idea of individuals, though, that Susan brought up, and that I've been scratching my head about as well, frankly? I mean, if there's fraud on the part of these institutions, even from a civil standpoint, why individuals did it, right? Why aren't they going after individuals?
Well, I think, I think folks have heard the Justice Department's response. It's been effective or not so effective in different contexts. They've gone after an enormous number of individuals. They've had the most success going after, lower level individuals where the fraud bubbled up from. The loss in Bear Stearns was a significant loss. And one of the things we learned from the financial crisis was the complexity of these financial products, the number of fingers that were in these pies. And when you're in that situation, there are not easy cases to bring to say, well, this is the person who committed fraud. All these other folks who were somehow involved in this, either you're going to go after all of them or you're sort of giving them a pass. So they are, I think, the department has said that often. They were, challenging cases to bring. And I think that, that's borne out by a lot of the other law enforcers who've looked at it.
Rachel, if we had consumers at these agencies, maybe not necessarily at the Justice Department as prosecutors, but at the SEC and the other regulators, would we be hearing different responses from enforcement people up here tonight?
I'm not sure, because I think if you think about the issues, here's an example, is I think there's the too big to fail problem that we've all heard about, that the biggest institutions aren't on that list because we can't regulate them or do anything about it. We have to bail them out because otherwise the economy will go. And now we're seeing what people have coined the too big to jail problem, which is we can't prosecute them either, even if it turns out they're funneling money to drug smugglers and terrorists because it's just too big of a bank. And the Department of Justice said that. They said that's we just have to live with that with HSBC. And why is it that they think that it's too big to prosecute? Well, I guess they consulted people at Treasury, which they said, and they asked kind of what would be the consequences on the markets. And I think if you had consumers at the table, they'd at least have to consult more broadly and really think about that. And I think if you had consumers at the agencies, you might have more proactive, a more proactive movement right now to break some of the big banks up. Because if at the end of the day, you get to the point that you can't prosecute them and you can't regulate them as big as they are because of the consequences on the economy, it doesn't take a hugely logical mind to say, well, perhaps they should be made smaller, because then you could regulate them and you could prosecute them. Maybe that's what we need to do. And I think what a consumer perspective, that's what we're hearing from the consumer groups right now. I mean, if you talk among that community, that's what they say. They say, why aren't there increased capitalization requirements for these institutions? Why aren't they smaller? And I think they're asking good questions, and I'm just not sure that anybody in the regulated entities are listening. And I think if they had a seat at the table, I think that they might.
Martin, if you had consumers at the New York Fed, would they give you a different perspective, or would they just gum up the works?
So the Federal Reserve consults broadly and has advisory committees of consumers and meets regularly with that group and others to get the broadest range of inputs in our policymaking decisions. So whether if the idea of a consumer advocate position is an interesting one.
Are they telling you that the banks are not capitalized enough? Are they? I mean, the consumers that you're consulting with, what kind of input are you getting?
Well, the minutes of their meetings are published pretty regularly, but recently it's really about economic conditions. People are very concerned about the prolonged nature of our recession, and what are things, how are things going to happen for people on Main Street, and so we get a lot of dialogue and conversation around.
But can you give me a practical idea of how that's put to use? You talked about how industry people helped the Fed understand what was going on during the crisis. How have consumers helped shape your understanding of things?
I was going to say probably the most famous example is Ned Gramlich, former governor of the Federal Reserve, heard about, was leading some of the consumer efforts and the mortgage crisis he thought was larger and bigger than the Federal Reserve, other members of the board considered, and so he pressed that issue until his last days at the Fed. And so, I mean, so there was a voice for that, and we probably should have, of course, in retrospect, we should have taken his, words more seriously and changed some of our policy, but it wasn't because people weren't heard. It was that people had different conclusions, and we have been in a 5-year period of reflection about how we could do our job better, and we have a whole series where we listen to our critics and really try to take that seriously. So,
Joe, talk about how consumers, investors are heard at the S.E.C. I know there's investor advocate office, I believe, and you're hearing from the public all the time. How is that put to use? And compare that to the former industry people, the industry people who are talking to the S.E.C. How does the average investor plan?
On the enforcement side, I mean, we actually have a fair bit of input from consumers, because one of the big inputs to our enforcement process is just complaints, tips, referrals, phone calls, letters, emails, just from the public. People who think they've been defrauded, people who think their relatives have been defrauded, and they're understandably very vocal about it, and they express their views, and when they don't think people are taking them seriously, they express their views again pretty vocally. So there's a lot of direct input on the enforcement side. Some of the things that come in are very small scale, and that's where sometimes we'll end up referring them to a state AG, a local prosecutor, a local securities regulator. But we get there's a lot of dialogue back and forth. I think some of the things that Rachel was talking about is consumer input more at a policy level, and would be some more at the commission rather on the enforcement side. But we have a lot of back and forth with investors.
But I mean, when you hear from industry people who can tell you the ins and outs of a CDO, or can tell you about money market mutual funds, and I recognize that a lot of this is at the commission level, versus consumers who might tell you that as much and as deep of information, but from a different perspective. Are they really looked at the same way?
Listen, consumers are the witnesses, the defrauded witnesses in many of our cases. I mean, they're the people who can tell us how they were lied to, how they were scammed, how their parents, their siblings were taken in by a scheme, and how it worked, and can point us in the directions of the people who did it. I mean, that's where the facts are, that's where the evidence is. And so that's a day-to-day interaction with those folks.
I want to switch gears a little bit. Tom, you talked about investing in enforcement, and this whole idea of whether people can make it working for the public sector, or they need to go through that revolving door to make a living. I spoke to Rob Kazami the day that he resigned, and he said, and I'm not telling anything out of school, he said, I got to make some money. I have young kids, and that's part of why I'm leaving. So talk a little bit more about how that factors in here, and is that, I mean, it gets back to the core question, and then we'll get to the audience questions in a moment. Are people looking out down the road at where am I going to work next?
I mean, I think, and let's face it, and it's too strong to say need, right? Because government lawyers, compared to the average American, make a pretty healthy wage. It's about, but I do think people look at their careers and think, well, I can do this job, which is very satisfying, or I could do this other job, which is less satisfying, but for substantially more money, and you make trade-offs at different times in your life. And that's completely understandable and rational. As I said at the outset, I do think that the delta has gotten so big that I think that's unfortunate, and it's endemic of any number of choices I think we make, whether it's not paying teachers enough or other things that I think we ought to rethink. when I think about investments of enforcement, it's in enforcement and regulatory regimes. You know, the CFPB, for example, is an investment in enforcement, and I think, you know, we hopefully are going to see some terrific results out of that. But I think of, you know, the Justice Department throws these stats out all the time about, you know, you invest $1 in healthcare fraud enforcement and you're going to get, you know, $4, $5, $8 back. You know, my experience was that there are a number of areas where that is absolutely, you know, I can't give you with precision how many dollars it is, but that society will benefit greatly if we spent more money in some of those areas. And I think that that is something that, look, no one on Capitol Hill likes to spend more money on lawyers. They like to spend a little more money on FBI agents. But it is a case that really deserves to be made because, as with most anything, if you actually invest more, I think you get better outcomes.
Matt, I want to get your take on this too, because I think you have a different perspective. You were in the public sector, went to the private sector. Is you someday like to go back to the public sector? And Tom said that frequently the government is now outgunned by the private bar.
I thought that was a striking comment that in 6 months he will regret, and in a couple of years in private practice he will recant altogether. So look, here's what I think. There's two different questions. One is the investment in enforcement resources, and this is a little bit aside from the panel. I think the country has spent plenty on enforcement resources at this point, and that there's a balance in terms of social investment that should probably go in another direction. I think that's for a different panel. As it relates to the kind of the working wage paid to people in government who are attracted to leave. You know, if the median income of a family of four in this country is $49,000, the idea that someone is suffering at $100,000 or $120,000 in the U.S. Attorney's Office is a little bit of a stretch. And to Tom's point, it's about choice and the opportunity cost of someone who could be in the private sector making $2 million, who chooses to stay for $150,000, is a meaningful decision that they have to make. It's a high-class problem that I think really only exists in Washington, maybe in Dallas, maybe Chicago, maybe Boston. It's not, you know, if you're the U.S. Attorney in Salt Lake City or Columbus, you're doing just fine. If you're in an AUSA, indeed, you may have one of the more attractive jobs there, both in terms of salary as well as in terms of responsibilities. I think the appeal of being in the government is the experience, the ability to do good, the chance, the opportunity to really develop skills that you don't get to develop in private practice in the same way. And so to me, it's a bit about personal investment, and the reward is not the financial reward. And so to me, again, mobility is important. I think it's important that people be able to raise families in a way that is consistent with what their wives want, which is why I left. And I think it's also important that people be able to go back when they feel like they've reached a point in their career where they want to give back again. And so to me, I don't think it's a wage issue, I don't think it's a salary issue, but I do think it's important that we have mobility.
Okay, let's open this up a little bit. And as it happens, we were talking about this POGO study, and Michael Smallberg of POGO, who was the author of the study, is here, and he's given the, where are you, Michael? Good to see you. We talked on the phone the other day. He writes, when we filed a FOIA request for records showing how the S.E.C. has dealt with potential conflicts of interest involving S.E.C. Commissioner Dan Gallagher, a former partner at WilmerHale, the agency withheld approximately 1,500 pages in their entirety. How well can Commissioner Gallagher and the S.E.C. function if they have to devote 1,500 pages to sorting out his potential conflicts? And why shouldn't those 1,500 pages be released to the public so the American people can see how his ethical entanglements are addressed? Want to take that one on? I mean, I'll spare you a little bit. I mean, it gets to the issue, though, of transparency, which is one of the takeaways from the POGO study.
Yeah, I mean, it's taking the second first. I mean, I have no idea why FOIA responded the way it did, and why they redacted things or withheld things, or why they didn't. I have some expertise in the world, but FOIA is not it's not one of it. But in terms of the other part of your question, which is the burden of doing all this stuff, it's a fair question, but I think it's okay. I mean, it's been, having gone through the transition, I had a lot of conflicts when I first started at the agency. It was very time-consuming and distracting to make sure that I was working on things I could work on and not working on things I can't work on, and documenting it right. But I think that's worth the time, and it's not debilitating. I mean, there's been some discussion about how people may have so many conflicts that it takes them either too long to work through them, or they get disqualified from too many matters to be able to do anything effective. I don't think that's right. I mean, we have hundreds and hundreds of enforcement cases every year, and there's plenty of talent to go around. So I think the burden of doing right is fine, and we can still do our work.
I think we can agree, though, that you can't get rid of conflicts, but one of the ways to cure them is disclosure. 1,500 pages were withheld, and again, we don't know why. But isn't there a problem, and I'll throw this out to the panel, with transparency, and isn't that a way to deal with this revolving door?
I'll just give one quick answer, which is that I'm not sure it's a problem if those documents go, as I suspect they probably are, to matters in which he's not participating. I mean, that's what that process is for. It's to identify matters in which he's not allowed to participate.
But we'll never know. Anybody else want to tackle that? Let me move on then to another question. Noreen Justy, and pardon me if I'm mispronouncing the name. One company may be too big to fail, but one person is not too big to go to jail. It's more a comment than a question. Does anybody want to, I mean, and Noreen has some more here, it looks like. Talk about that. I mean, it kind of gets to what we talked about before, but why, again, why aren't we seeing individuals, at the very least on a civil level, being charged here?
Well, I think to go back on the criminal side, which I think is more, look, I think a lot of people in the public and the commenter, I think, nobody can disagree with the idea that anybody should be above the law. I think it speaks to the challenge of making these cases, and ultimately the department decided not to pursue them, and has said repeatedly that these are incredibly hard cases to make.
We also, I think, if anybody wants to just come up to a microphone, we can do it that way as well, over there. So in the meantime, we have a couple more from Noreen. How easy or hard is it to find an industry expert who is willing to testify against the industry? I mean, we see cooperating witnesses all the time, but I'll throw that out to you, Matt.
I haven't heard of any problem at all in making complaints, filing key TAMs, or in civil lawsuits against us. I think there's a fairly robust industry on both sides of expert witnesses and testimony, so I don't think there's a paucity on either side of the table.
I think if you're talking about people who are actually in the industry as opposed to people who work for consulting firms, otherwise it's hard. I mean, you just have to, there are both economic and other reasons why it's hard to find people who are currently in the business who want to be able to testify that what colleagues at their firms or other firms have done is not appropriate.
And I do think, one thing that I've seen repeatedly in the government was you're taking major investigations take a substantial period of time. You're unlikely to want to spend the money on the highest end expert until you have some sense that your case is going to proceed. And at that point, particularly in the largest matters, big antitrust matters, for example, folks have been sort of snapped up, much earlier in the process. And when you move into even more esoteric areas, frankly, economics has raised fewer problems for us. Like, say you have a major oil spill, for example, finding expertise outside the industry is a challenge.
Right.
And the cost of it is very substantial. I mean, I've had a case a couple weeks ago where the lawyer on the other side said, we've got an expert, he's a Nobel Prize winner. You want a couple more Nobel Prize winners? I'll find them for you. No problem. We can't do that.
Joe, talk a little bit, if you will, about the whistleblower program at the S.E.C. Because, and in fairness to the S.E.C., because we, again, have beaten up on you a bunch, there have been a great number of changes in the last 4 years, and that's one of them that came out of the Madoff scandal, and just the inability of the agency before to catch whistleblowers. And it gets to this idea of, are there experts out there, are there people in this industry, rather than coming in and out of the revolving door, that can be induced to testify and help you in cases in that way?
Look, the program is still pretty young. It's really been in effect for a little more than a year, but from our perspective, it's been very, very successful. I mean, it's doing all the things that we hoped it would do. We're getting information from people who have firsthand knowledge of frauds and misconduct from the inside of entities, It allows us to do investigations more quickly, in a more targeted way. You don't have to spend 2 years doing it because you know where to look and where to go right away. It's too early to talk about ultimately the success of it. We paid out our first whistleblower bonus this year, and there are more in the pipeline. I think you'll see more this year. And it's really, I think it's turning out, all the signs are that it's doing exactly what we'd hoped it would do.
I think we have a question in the back.
What are your thoughts about state attorneys general who hire or retain outside counsel to investigate and prosecute financial institutions?
Anybody?
I mean, I don't actually have a problem with that. I think there are choices that have to be made, and I think there is a question of transparency. If you're, you want to see what your attorney general is obviously paying and the kind of agreement they've entered into. I think that's understandable. But I think there are a bunch of attorneys general, and I spent a lot of time working closely with them, where they needed to they had some difficult choices to make about how they were going to pursue all the matters that they wanted to pursue, and that's one way to extend their reach. That's another reason why the AGs often get together and work collaboratively, because for the largest cases, they need to do that. I'll say the Justice Department occasionally has brought in people from the outside, particularly in the antitrust area, not hiring firms necessarily, but bringing in individual litigators where we felt like we needed particular expertise to litigate particular matters.
But I will say, I think it's really important that the AG be making the key decisions, because, otherwise you are giving a public enforcement role to a law firm that has only a financial stake in the outcome. They set it up so that the law firm will make every decision with a profit motive, and we generally prefer to have the government make these decisions because they're supposed to be looking out for the public interest and not just dollar figures. So I think for that arrangement to not raise serious problems, it still should be the decision of the elected attorney, or in some states the ones that have appointed AGs, that they really are making the key shots. And in some sense, it's more like the private firm is like their in-house counsel. But if it turns out what it really is delegating the authority to a private actor, I think that raises a lot of really, really fundamental questions about why are you bringing the action, because their motive is going to be entirely money.
I'm happy to hear Rachel say that, actually, because I do think if we've got these serious questions around conflicts and are putting emphasis on transparency, which I said is important in this context, you'd like to have that same transparency. You'd like to understand, was there an RFP, or is it a friend of the Attorney General or someone in their office? You'd like to understand. When you bring in David Boies to do an antitrust case, it's a totally different animal than when a local Attorney General hires a firm where either he's come from or going back to when there's a financial incentive where they're running the case themselves. And whether it's real or perceived, whether it's an appearance or not, you have nowhere near the types of disclosure and transparency that we do have at the S.E.C. So I think it's actually an area for focus, and I would hope the academics and media would start looking more.
And particularly in a case that doesn't go to trial and settles, and we never know. Is that where the real? At trial at least they can be, impeached or whatever.
But they can. So it's a good point, Scott. And obviously, overwhelmingly, look, one of the things I didn't respond to, which Tom said, around the disparity in resources, is there may be a disparity in resources against a large financial services company or large public company in the government, but there's a complete asymmetry around power and ability to create bad results. And so, and that's true for the attorneys general as well, and they can end up creating settlement dynamics where you end up with a settlement because you really don't have a lot of choice. So yes, it's true, but no, you don't get to impeach the attorney for the other side. You don't get to impeach his motives. You get to impeach the witnesses, but you don't get any transparency into the relationship between the elected official and the firm that's been retained, et cetera.
Another question in the back?
I don't know if this is an issue of revolving door or of mindset, as you referred to earlier, but would some of you like to address the apparent power of financial institutions over the drafting of regulations?
Or lack thereof in the case of the CFPB. Also to Rachel's point around we need to have a consumer advocate at the table. We not only have a consumer advocate at the table, we have an entire agency dedicated to giving voice to consumer advocates. Look, there's a public process around regulation. I think it's probably more transparent than, say, universities But in terms of input from industry, I think it's critically important that legislators and rulemakers get input from all perspectives, which includes advocates as well as industry. Otherwise, you end up with very bad results. In legislation, it's got a good intention, but ends up being drafted in such a way that there are unintended consequences.
But
Please?
can I just jump
Yeah,
in for
yeah,
a second,
please.
though? Because, I mean, I think that if you are an agency and you're asking yourself, who's likely to challenge me based on these rules, it's obviously going to be the well-financed and well-organized industry that you're always thinking about when you're writing regulations. When you figure out what regulations should say, because of the expertise of the industry, you know, it's your point. Who knows how this works? Well, the industry does, and so there's a built-in bias in this system, and it tilts toward industry. And in the congressional overseers, the oversight committees that control the budgets of all the most of the regulatory agencies that deal with finance, you know, where do they get their donations? Where is it that who has political power in our system? I mean, these aren't really radical concepts. I mean, capture's been well documented by political scientists. It's hard to measure, but at least the power, the relative power of well-financed and organized financial interests far outweighs the dispersed interests of consumers out there. And so it's absolutely the case that they have greater say and greater influence over the regulations that are enacted. And, you know, I think, yes, now we have a CFPB. I mean, it's a brand new agency. It's unclear exactly how effective it'll ultimately be. But if we look at the history of the financial regulators up until that point, consumer interest really took a backseat to things like safety and soundness and the kinds of concerns that they predominantly cared about, you know, rightly or wrongly. But I do think that it's probably a bigger issue with the regulations, frankly, than it even is with enforcement. And, you know, the idea, just one last point about the, you know, I don't think the consumer advocate should be something like my mother. The idea is that the consumer advocate would be, you know, really it shouldn't be her, would be somebody like, you know, an MIT economist, you know, someone who's studied exactly what it is that these industries have, you know, what should we require of banks? And there's lots of economists now that are studying these kinds of things. They're just outside the industry. So I think it would be valuable to do that, particularly for regulation. I think, in fact, it's probably a bigger issue for regulation than it is for enforcement.
Isn't it possible, though, and I also want Susan for you to weigh into this on this as well, that there are people in industry who aren't just looking out for their own self-interest, but just the practical implications, the unintended consequences of these regulations, and they have a perspective that maybe should be listened to without that sort of jaundiced eye?
Yeah, I mean, of course, I think the issue is they are getting listened to. I think the reason we're having this conversation is not because, oh, the poor banks, no one ever listens to what they have to say. I think the issue is that everybody listens to them, and they say, look, if you want the economy to keep working, you can't let anything happen to us, because, you know, we're basically the largest chunk of the economy, and you have to listen to them. If you don't listen to them, they're basically saying the world as we know it will collapse. So they're gonna get a seat at the table, and I think the issue is, do you have a counterbalanced view, and where do you get it? And I think, you know, it's not an easy task. I am certain for the Department of Justice to sit there and try to think about, if we bring this action and this bank goes down, is that really going to mean that the entire economy caves? That's a pretty scary thought, I would imagine, for either a prosecutor or a regulator. And the question is, though, where do they get the information on the other side to potentially make a different choice?
So this is Martin Grant. I haven't seen so many of you on this side. The Federal Reserve has responded to the financial crisis in a way that, you know, and the Congress has responded in passing Dodd-Frank and having so many regulations to have to be written and studies to be done, but the set of folks that are dedicated to policy are very much interested in reform and making ours, you know, our country more, you know, financially stable, and that we would prevent any crisis in the future, and that, and so yes, there are lots of people at the table and lots of powerful interests speaking, but the public interest is something that is very real in this area, and that people are working very hard and carefully to, you know, get the right solutions in the regulations, and it's been a very long, you know, they're behind, but it's only because people care so much to get the answers right. So,
Susan?
You know, if you look at the rulemaking information that the S.E.C. puts right on its website, just go to any rule, and particularly if you look at the Dodd-Frank back and forth, you'll see that the preponderance of the meetings that the SEC has is with the industry, or with the Financial Services Roundtable, or, fill in the blank with a bank's name. And every once in a while, you see some poor, literally poverty-stricken consumer advocate in there too. But, how many times, there's the Consumer Federation of America, and Barb Roper is there, and she's very vocal. And there's Better Markets, a guy named Dennis Kelleher does some good work on the consumer side. But how much work can those two people do? And I can promise you, they are not at the cocktail parties with the SEC alumni and the current SEC people. But you can just look at those filings and you see that there's no voice. And why is there no voice? Who can fund that from the consumer side? Better Markets is funded by a hedge fund guy who just decided he would throw a few $1 million into this project. Consumer Federation of America has one person. She's really good, but it's one person. So the talent is so lopsided. I think Rachel's idea is great. An MIT economist. We should be drawing much more on the academic community, I think. I don't know why we don't. There certainly are some terrific academics who understand. They should have Rachel on these boards.
I think you want a real yeah.
I think her mother's got that space taken.
I think you're right.
All right, we promised we would get you out of here by 8 o'clock, and that's right about where we are. I think Joe has one of those cocktail parties to go to for the... Sorry. Thank you very much for great questions, a great panel, and a topic that is not going to end anytime soon. Thank you very, very much.